Good morning,
Good
ma'am.
morning, ma'am. Good morning.
What is your name, please?
Shante Johnson.
Thank you. Johnson, what case are you here for this morning?
I'm here for the landlord tenant case with Mac and his attorney Miller.
With who?
My landlord Mac.
She's in the right place.
Okay,
It's Shantu Johnson and Mac Tedla.
Yes.
It's 9:30, Marianne.
thank you.
I just didn't want to be late. Wanted to be on time.
You're fine.
Okay. What in what way else? Which way to go?
Yeah, last minute, got it. So I guess that's their courtroom.
Mr. Sefton, are you ready with Mr. Evans, is it?
Yes, ma'am. We have agreements on both of those. So I have to just put them on the record and you can turp us out of there.
Don't, ask for you. Okay. Minutes.
Ma'am? Thank you. This is 224766 GC. This is Midland Credit Management versus Michael Evans. May I have your appearances, please?
Michael W. Sefton, SEFTON P31320 for Midland Midland Funding.
Mr. Evans, state your name for me, please, sir.
Michael Evans.
Thank you. Today is the day and time set for the plaintiff's motion for summary disposition. Mr. Sefton, you've indicated that there is an agreement in this matter.
Yes, Your Honor. There will be a consent judgment coming in. Uh, they're offering a payment of a percentage of that within 90 days. That'll be put on the record. If it does not come, if that payment is not made, then there'll be payments made at $50 a month until the balance is paid in full. They'll be sending in a different judgment which reflects that clearly, because I think it confuses the court when they say X dollars. And Mr. Evans, who's been very polite, has given me his email address and telephone number so they can communicate directly with the plaintiff's counsel and have this matter settled. Probably the judgment should hit the court within 14 days.
Well, Mr. Sefton, if you would place the actual dollar amounts on the record for me, please.
You're going to ask me that. Hold on a minute. If the judgment is paid within 90 days, the balance, the judgment will be $913.83. If it is not paid within that period of time, up to here, it's 1,100. I'm sorry.
Is it the 1244.54, which includes the principal plus the cost?
I believe this is the 1,100. It's an 1,100. Hold on a minute here. There. And naturally, I've let that one escape. Too many computers, too many iPads to keep everything.
Well, Mr. Sefton, the law firm sent over a judgment that shows principal damages of $1,142.29, filing fee of $55, service fee of $47.25 for a total judgment of $1,244.54. And my question to you is that the
Yes,
dollar amount that he would be paying if he doesn't pay the settlement amount in 90 days? Would that be the balance that he's paying
yes,
$50 per month payments on? Okay,
yes, ma'am.
okay.
You can
So,
confirm that.
Mr. Sefton, what I will actually do, because the promise of a consent judgment doesn't equal consent judgment, I
Okay,
will adjourn this matter, adjourn the plaintiff's motion for summary disposition and pretrial to May the 2nd, 2023 at 9 a.m. If the consent judgment comes in before that, Mr. Evans, if it's signed by you and signed by the law firm before that date and received by the court, you will not have to appear. That date is just to make sure the paperwork comes in. May 2nd at 9 a.m. unless the consent judgment is received, fully executed before that date. That makes sense to you, Mr. Sefton?
it does, Your Honor.
Mr. Evans, I was doing the procedural part without asking you. You were able to hear Mr. Sefton just now?
Yes, yes, I was, Your Honor.
And it's your agreement that there will be a settlement of $913.83 within the next 90 days or payments on the full balance?
Yes, Your Honor.
Did you have any questions about your conversation with Mr. Sefton?
No.
And that's how you wish to proceed, sir?
Yes, Your Honor.
Then the court will await receipt of the signed consent judgment. Otherwise, I'll see you back here on May the 2nd at 9 a.m. with an explanation of why that consent judgment hasn't come in yet, okay?
Yes.
Anything else, Mr. Evans?
No, Your Honor. I'm fine.
Have a great day, sir. Thank you for being so timely this morning.
You also. Thank you.
Thank you.
Bye.
And Mr. Sefton, it's your indication that you've already talked to Mr. Mathis as well?
Yes, Your Honor. Another very polite gentleman.
This is 230070 GC. This is Midland Credit Management versus Terrence Mathis. May I have your appearances, please?
Michael W. Sefton, SEFTON P31320, appearing on behalf of Midland Funding Credit Management.
Mr. Mathis, state your name for me, please, sir.
Terrence Mathis, Your Honor.
Thank you. Today was the day and time set for the pretrial in this matter. Mr. Sefton, you've indicated a resolution in this matter as well.
Essentially, it's the exact same resolution that we had with the prior one. The I think we'll do for control purposes, the same thing you just did. The amount on this one, if 80% is paid, is $1,027.63 within 90 days. If not, he will take the payment option of $50 a month. If you can confirm with that with him, if that is what he wants to do, and then we'll just set a control date to see if it's taken care of by the May 2nd date you've given the other one.
Mr. Mathis, were you able to hear Mr. Sefton just now?
Yes, ma'am, Your Honor.
And thank you. And sir, it's your understanding that this matter will be settled with you paying $1,027.63 within 90 days of today's date?
Yes, ma'am.
And if you don't pay that amount, that there will be a consent judgment for $50 per month payments?
Yes, ma'am.
And Mr. Sefton, is it your understanding that there will be a signed consent judgment that has both of these provisions on it?
I would love to say that's exactly my understanding, Your Honor, but unfortunately, I am sitting in Las Vegas, Nevada in 31-degree weather with the wind blowing, and I get hired by the firm in Michigan, they get hires a firm in California that hires me from Lake Odessa, and I'm on vacation. So I would love to tell you that I know exactly what's going on there. They have thousands of attorneys, and I can say that's my best hope, because that's what I put in my report and say, please get this thing done. But I would say leave the control date on there, and then that way at least they're required to show up and do the control date and get it done. I think you gave the the other control date for May 2nd at 9 a.m. Is that correct?
That's correct. But Mr. Mathis, if this is in fact your agreement and Mr. Sefton sends the report back to, is it Encore Capital now? I don't remember the name.
No,
of the
this
law firm.
is
They changed
Midland.
it.
It's Midland Funding versus Terrence Mathis, Midland Credit Management, Midland, whoever they are at the current
I don't
state.
think the name of the law firm is Midland though, Mr. Sefton. I thought it was something else, but that's an aside more than anything else. Mr. Mathis, if there has been an agreement, Mr. Sefton's report to the law firm will be that these are the terms the party agreed to, and you should be receiving something to sign and send back to them. They'll sign it and send it into the court. The notes in the file indicate that there has been a settlement of either this payoff in 90 days or $50 per month payments on the full balance. And so long as it's signed by you and an attorney from the law firm and back here before May 2nd, you don't need to log back on. I will just sign off on the consent judgment and a copy will be mailed out to you. Any questions, Mr. Mathis?
I understand, Your Honor. Thank you.
Thank you, sir. Have a good day.
You as
And this,
well.
Your Honor, you did leave the control date on there. Is that correct?
May 2nd at 9 a.m.
All right. I
And
want to make sure.
notices will be mailed out to the law firm.
Thank you. Have a good day, Your Honor. Thank you, Mr.
You
Mathis.
too, thank you.
Thank you, sir.
Mr. Monroe, my policy is 15 minutes after the scheduled start time. So we'll keep an eye out for Miss Welch, and if she's not here by 9:30, I'll call your case and get you on with your day.
I'll stand by, Your Honor. Thank you.
Thank you. Mr. Burke, have we seen Sean Story?
I have not, Your Honor.
This is 224955 GC. This is Beaumont Health versus Sean Story. May I have your appearance, sir?
Thank you, Your Honor. Hal Burke, P6906A, the attorney for Beaumont Health on this case.
Sean Story. Good morning, Mr. Collis. This case was scheduled this morning at 9 a.m. for an adjourned pretrial, and the parties were here back on February 21st. They indicated that there was a consent judgment that would be forthcoming. When I checked late yesterday afternoon, Mr. Burke, we had not received an executed consent judgment. Case scheduled at 9 o'clock. It's now 9:15 by this court's clock. I've called the name of Sean Story now 3 times. It appears that the defendant has failed to appear this morning. How do you wish to proceed?
Your Honor, we also have not received back the signed consent judgment. I defer to you. Instead of requesting a default, would you consider one last time? We are trying to work with him. If not, maybe a default under the 7-day rule.
Mr. Burke, it's your case. You tell me how you wish to proceed. The case was filed back in September. The answer was filed in December 2022, and the party's first appearance was just over a month ago. So if you want a default judgment, the court is happy to entertain that this morning. If you'd rather adjourn the case till May 2nd at 9 a.m., I'm happy to do that. You tell me.
How about a default judgment under the 7-day rule, and we'll get his attention, try to get his attention that way, Your Honor.
Default judgment will enter based on the defendant's failure to appear this morning. Would you put your principal balance and cost on the record, please, sir?
Sure, Your Honor. The original balance was $1,505.83, 150583. With court costs now, the balance is $1,784.08. And that will be written in the proposed default judgment.
Thank you. Defendant having failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with total due of $1,784.08. Plaintiff's attorney will submit that judgment to the court pursuant to the 7-day rule. Anything else in this case, Mr. Burke?
Nothing, Your Honor. Thank you.
Thank you, sir.
Have a great day.
You too. Thank you. Mr. Collis, have you spoken to Mr. Brown?
They're going into a breakout room right now, Judge.
Thank you.
Mr. Brown, you should see an invitation to join a breakout room.
I see him.
You see him in here? It is not your case, please make sure you remain muted. You repeat it. Thank you.
This is 225471 GC. This is Forest Health Medical Center versus Andrew Brown. Your appearances, please.
For the record, Your Honor, Stuart Collis, P49530, on behalf of the plaintiff.
Mr. Brown, unmute yourself and state your name for the record, sir.
Your Honor, oh, there he goes.
Oh, am I unmuted?
Yes, now you're unmuted.
You are now, sir.
Thank you.
State your name, sir.
Andrew Brown.
Thank you. Today is the day and time set for the pretrial in this matter. Mr. Collis, how are we proceeding?
Well, Your Honor, Mr. Brown couldn't get on mute in the breakout room, so here we are. From what I could see, and Mr. Brown, correct me if I'm wrong, I don't think he's denying the debt. I think he was unaware of the debt, if that's an accurate statement.
Well,
Brown-
I'm sorry, Mr. Collis, now that Mr. Brown's unmuted, do you want to go back in the breakout room and have a
we
conversation?
could certainly try, yes, absolutely.
Let's try that.
All right, thank you.
Mr. Brown, you should be able to navigate back where you just came from. Please go in there and have a conversation with Mr. Collis. Marianne, if they come out, I'll be right back. Good morning, Mr. Schisler. We have not seen Mr. Stanford as of yet. Good morning, Mr. Ivanchik.
Good morning, Your Honor.
Mr. Harris is here. Do you need to go into a breakout room?
Is Mr. Harris the defendant? Oh, sorry, Mr. Harris is the attorney.
He's the
Yes.
attorney.
If you could, we've already spoken, but that's okay.
No, if you're ready, I'll call the case.
Yeah, if you wouldn't mind, Your Honor, yeah, call it and I'll address some of the other issues.
Thank you. On the docket this morning, there is 226086 GC. Well, give me a second. That's 9:30. We have a few cases that should be brief. I know yours is a little bit more complicated. This is a recall of 225471 GC Forest Health versus Andrew Brown. I have your appearances. You've now had an opportunity to speak. Mr. Collis, how are we proceeding?
Yes, Your Honor. We're gonna need some time. Mr. Brown wants to work with his insurance company to see if we can get some of this paid. I'm gonna need a HIPAA form from him in order to get him the documentation he's gonna need. So if we could have about 90 days of discovery, that would be a good start on this case, and hopefully we could resolve it before then.
Mr. Brown, is that how you wish to proceed in this case?
Yes, ma'am.
90 days puts us on the 4th of July-ish, and
I'm not gonna be here the 4th
civil
of July. I
docket.
don't think you will either.
We reset our civil docket for July the 18th. So we will adjourn this pretrial over to July the 18th at 9 a.m. Discovery shall commence immediately. Mr. Brown, if you receive documents from the plaintiff's office that require you, that were asked you to respond or provide documentation, please respond to those accordingly. Additionally, if there are documents or questions you have for Forest Health, please send them in writing to Mr. Collis's office. We're adjourning the pretrial to July 18th at 9 a.m. back on Zoom, back here with me. Is there anything else in this case, Mr. Collis?
Thank you.
No, Your Honor.
Anything else, Mr. Brown?
No, Your Honor. Thank you.
You're welcome. Discovery opens immediately and will extend to the adjourned pretrial date. Have a good day, Mr. Brown. You're free to go.
Thank you.
Have a great day, Your
Thank
Honor.
You have.
You too, sir. Mr. Monroe,
Yes, ma'am.
I thought I just saw.
I did too, but I don't think it was her.
I thought it was.
Might be. You might give her a call.
Well, she came on and then disappeared. So I hold on to the file for just a minute longer. Mary Ann,
Yes, ma'am.
did you see Okila?
You know, it happened so
Appeared in
fast that I didn't catch the name.
It was Okila. It didn't match the last name of Welsh that we have on the docket, and I don't want to hold Mr. Monroe too much longer. So we'll hold on to it just for a little bit. This is 226086 GC. This is LBK Homes versus Keon Wilson, April Boykins, and Devin Simpson.
Good morning, Your Honor. John Ivanchuk on behalf of the plaintiff.
Good morning, Your Honor. Jamal Harris, appearing on behalf of defendants Keon Wilson, April Boykins. My P number is 63835.
Also, it's not on the docket until next month, but I have the file that is 225886 GC, which appears to include the same parties or some of the same parties.
It's all the same parties and it's the
It's
same
all.
issue. Yeah, and if the court wouldn't mind consolidating the two and canceling the hearing for next month, that would be appreciative.
Here's the problem. The captions are not the same, and Mr. Lavasser has a motion. Well, this is what triggered the issue from my perspective. We received a first amended complaint that lists the plaintiffs as improper, but is signed by an attorney.
Your Honor, you can make that correction because it is small claims and it's under a different case. And I think we were planning to consolidate it. So I was hoping that we would, and I know he sent paperwork to my client saying that, you know, that he was going to do a motion to consolidate the cases.
Who sent something to your clients? Mr. Ivanchuk?
Yeah, Vanchek, not a motion, but there's some paperwork, I believe, attempt to combine these two cases.
I think it was I probably mentioned a motion for more definite statement, Your Honor, on the small claims case, but then Mr. Harris was retained. He did send a amended complaint as we had discussed. And yeah, it looks like it's got the SC case number on it and Mr. Wilson and Ms. Boykin as improper. I'm guessing that was probably a typo. Yeah, so it would make sense to consolidate these cases unless there's an objection by the court.
I have no objection, but when there's two attorneys involved and I have these cases that are filed within 2 weeks of each other floating around and the paperwork captions don't match either file exactly, and Mr. Lavasser has now filed a motion to intervene, I just wanted the two primary attorneys here to say, A, Your Honor, yes, consolidate the cases. B, we're going to put the cases in the 5886 file because that was the first in time filed where the Wilson Boykins are the plaintiffs and Bazzi, and I presume the
LBK Homes R Us
should be the defendant. So then is the case not proceeding at all against Abek Boyaga? I'm butchering his name. He's listed as defendant number 3 in the 5886 case.
That I think I'm guessing, if I remember right, he is the real estate agent. I think that was involved here. If I remember right? Let me see if I can pull up the filings I have here.
Mr. Ivanchuk, let me say it a different way. The case you filed lists LBK as the plaintiff.
Yep.
And then the defendants as Wilson, Boykins, and Simpson.
Yeah, I believe Simpson was the real estate agent for you know what, let's call them buyers because this is a home sale transaction. buyers were Wilson and Boykins, seller was LBK Homes R Us and the Bazzi's, BAZZI. Yeah, so I think Mr. Simpson was the buyer's agent, and I wasn't aware that there was a motion filed by anybody, because I don't have it, but if there was, I'm thinking that it's probably the seller's agent.
Yeah, I've got some
Grant?
paperwork saying that they want to interplead on the SC case.
Yeah,
Randall Lavasser filed a motion to intervene by Royal Real Estate. It was received here on March the 27th, which that triggered this court's concern that there was a problem. And then Mr. Harris's amended pleading that inaccurately describes the party. So where I'm going, and my question before I was interrupted, was the first filed case was Wilson and Boykins, who are the buyers, correct?
correct.
Suing the sellers. And that is
Correct.
the case that Mr. Lavasser has a request to intervene. That is scheduled for May. That case was filed in November.
Yes,
Mr. Vanchek's case was filed in December, which lists the sellers as the plaintiff and the buyers as the defendant.
that's correct.
So the consolidation would be the December case into the first file case 225886 GC. I'm asking, not telling you.
I believe
how
that
did
that is typically the way it's done, is the lower, or the lowercase number is the one that we use for consolidation.
So if Mr. Vanchek, you said that you wanted to consolidate the cases, so I will be looking for a stipulated order from, I don't care who drafts it and how you fix it, but to get it here to consolidate the two cases, neaten up the captions so that we have the correct parties. If we are proceeding with Wilson and Boykins as the plaintiff's attorney, as the plaintiffs with Mr. Harris as their attorney, and the Bazzi LBK as the defendants, would it be 3 defendants or is it just LBK? Help me, Mr. Vanchek.
I think there's 3 defendants because on the 5886 case. I'm looking at the small claims cases that are documents that were filed here. And maybe I can answer the court's question. Yeah, it looks like there, yeah. Abadasi, Abagoye, yeah. I believe that would be the seller's agent. But I'll have to confirm that. But if we're consolidating it, it should include that defendant as well. And then we can just treat the after filed case as a counter complaint, I believe. But I'm still trying to find the motion that was filed. I don't see that I received it.
Mr. Lavasser's office. Oh, because Mr. Harris was not listed as the attorney. I'm looking on the Register of Actions. And Mr. Harris is not listed as the attorney in the 5886 file. Mr. Harris didn't become an issue in the 5886 case until the court received his first amended complaint on March the 27th.
Okay. Yeah, I see him listed on the Register of Action on the 6086 case. Yeah, I see Randall Lavasser is the attorney for Mr. I'm assuming that's the seller's agent. Or sorry, that would have to be, yeah, that would be the seller's agent based upon the grouping of the defendants here. So I guess to hopefully make this easier for the court, we'll file a stip in order to to consolidate the cases, and hopefully, drag Mr. Lavoisier in on it. I don't think he probably really cares, considering, who he represents.
Mr. I'm sorry, Mr. Harris, do you have a copy of Mr. Lavasser's motion?
I do. I did receive it in mail. I don't have it. Let me see if I have it in the file.
No. I
Okay.
don't need you to pull it out, but when you locate it, you might want to share it with Mr. Ivanchek because of how the issues it raises.
Okay, I definitely will.
And I don't know if the stip the two of you do will satisfy Mr. Lavasser. So before you submit
Yeah.
a consolidation, you might want to review the motion, Mr. Ivanchek, because it
That's
might
fine.
not eliminate the need for the May 2nd hearing.
Okay. Fair
I'm
enough.
saying this stuff procedurally so I can push the old case to the side, but if there's going to be a stipulation to consolidate the cases, was there anything to do in the only case that was scheduled for today, which was the 6086 case?
Sure. Your Honor, Mr. Harris and I had spoken, as I previously indicated, prior to the hearing. We had discussed doing mediation with Judge Green preferably. And I know she's kind of a little bit scheduling way out on these.
How long is it going to take you to get the stipulation together to consolidate the cases?
Yeah,
I
before
think-
we discuss mediation.
Go ahead.
Yeah, how long? Well, I think that was addressed to you to get the stipulation. How long you think it'll take, Counselor, for us to get that to the court? Are you going to draft it up for us, or?
Yeah, I can draft it. That's not a problem. And then we'll submit it to the civil email address, and hopefully it'll get processed semi-quickly.
Well, that's number one, because I'll keep an eye out for it and I'll put a note on the file for civil that I'm looking for because this is odd. And then the issue of Mr. Lavasser's request to intervene, does that need to be addressed before the remaining case goes to Judge Green for mediation?
Without having the motion in front of me, I can't really answer that, Your Honor.
So that's why I asked Mr. Harris to share it with you. So
Yeah,
what
fair
I'll
enough.
do, Mr. Ivanchek, is mark up the December file case, the 6086 case, that there will be a stipulation to adjourn. I'm sorry, stipulation to consolidate the cases with the ideal of the case going with the surviving case going to mediation with Judge Green. I will actually adjourn this case over to that May 2nd date at 9:15. In an interim, if the three of you, Mr. Harris, Mr. Ivanchek, and Mr. Lavasser, are able to neaten up what the caption is and who the properly named parties are, when we get here on May 2nd, we'll be able to then send it over to Judge Green. But I don't want to send it to Judge Green with the parties not lining up in terms of who's named in their positions and having Mr. Lavasser not privy to this conversation.
Understood.
Does that make
I-
sense to
I
you,
would
Mr.
agree.
Ivanchek?
It does, Your Honor.
Was
Yes.
there something else you wanted to cover or address regarding this case?
I don't think so. I was just checking to see, my client was having some trouble logging on and I still don't see her, although she might be the iPhone, I'm not sure. But no, I don't think, as far as this case, no. Other than, I'm sorry, counsel did submit discovery, but there's no order for discovery at this point.
How long of a discovery period are you looking for, Mr. Harris?
90 days.
Mr. Ivanchek?
I'd rather not do discovery at all, Your Honor. I believe that given the facts that we have here, mediation is probably the best course, given that, especially considering the amounts that we're talking about.
I would prefer to go through a discovery process, Sharon. Because this is a contractual issue and, we have our documents and I would like to see what counsel has on behalf of his client.
I think 90 days might be a little long, Mr. Harris, considering the fact that you've already prepared and filed with this court copies of your discovery request. Let's
Okay.
say 30 days discovery,
Hello.
and that will get us back to our return date. And we'll see where things stand then, and if there's been progress made in any conversation about either resolving the case or narrowing the issue of what will go before Judge Green for that mediation. Anything else, Mr. Harris?
No, Your Honor.
Anything else, Mr. Vancheck?
No, Your Honor.
Thank you.
Thank you, Your
I'll
Honor.
see you here on May 2nd at 9:15. And I'll have both cases in case there's some issue with the paperwork. I'll have them both scheduled on the same day at the same time, unless you have done something else to move it along differently.
Okay.
Thank
Thank
you,
you, Your Honor.
gentlemen.
Thank you, Your Honor.
Have a good day.
You too. Mary Ann, I'm going to hold on to those two files because I have to do something a little different to get them on track. This is 2263A2GC. This is Citibank versus Welch. May I have your appearance, please, sir?
Your Honor, I'm David R. Monroe, P18081, appearance counsel for Stenger and Stenger on behalf of Citibank.
Thank you, Mr. Monroe. Today was the day and time set for the pretrial. It was scheduled at 9:15. It's now 9:48 by the court's clock. The court at one point saw someone with a name that appeared to be the defendants, but they came and left quickly and they have not returned. We are now half an hour past the scheduled start time. There is no one here on behalf of the plaintiff. I'm sorry, on behalf of the defendant. How would you like to proceed, sir?
Now, if the court please, the plaintiff and the defendant have reached an agreement regarding a compromise settlement. The plaintiff prepared a judgment similar to the one that appears in your file and sent it to the defendant for signature, but has not received it back. The settlement amount was about $2,800, actually $2,820. And the defendant has already made one payment starting on April 4 of $117. So I think she's interested in continuing that. I would suggest, if the court please, that we set it up for another pretrial about 60 days out or 30, whatever the court wishes, to see if the defendant in fact signs and returns the proposed judgment. And if so, we can file it and that'll be the end of it. That's my,
Respectfully, Mr. Monroe, I'm sorry to interrupt you, sir. The issue is that the parties appeared back on March the 7th, and the court was advised that a consent judgment would be submitted. The terms were not placed on the record. The court put today's date in more as a control date than anything else. The court does not have a copy of the proposed consent judgment or any other settlement agreement by and between the parties. I'm happy to adjourn the case, but the defendant has not signed and returned the consent judgment that plaintiff's office sent out previously and has not appeared this morning. So if you want an adjournment, I'm happy to give it. But
well,
they're
I
not
was
here to
hoping that,
explain why they haven't.
I apologize for interrupting the court. I was hoping she would appear as well, Your Honor, so we could ask her whether she's gotten it and whether she intends to send it back. So let's, if the court please, adjourn it for a period of time for another pretrial, and hopefully it'll go away by that time.
Let's put it over, you said a period of time, May 2nd or June the 6th?
June 6th, at what time, Your Honor?
At 9 a.m. back on Zoom?
That's fine. I will let them know about that, Your Honor, and encourage them to contact her.
Anything else, Mr. Monroe?
No, thank you, ma'am.
Thank you for your patience, sir. Have a good day.
Appreciate being with you. Bye-bye.
Thank you. This is 210929GC. This is Gateway Financial versus Stanford. May I have your appearances, please?
Yes, good morning, Your Honor. May it please the court, Scott Schisler, 48832 on behalf of the plaintiff.
Sir, state your name for me, please. Mr. Stanford,
Oh, Salahuddin Stanford.
turn your video on for me, please, sir. Today is a day and time set for hearing on Mr. Stanford's objections to garnishment. Have the parties had the opportunity to speak?
Your Honor, we did not. I talked to my client about this. We've had two prior arrangements, neither of which was followed through. And so my client asked me to proceed with the hearing.
Thank you. Mr. Stanford, this is your objection. Please place your objection on the record.
My objection is to the garnishment because I wasn't told beforehand from my job where I ain't get no court documents. And I was wondering if I could get another judgment because I'm willing to return the car that's in question to them, and they can adjust the pricing as need be.
Mr. Schishler?
Your Honor, as I said, back in February of 21, we tried to get this resolved through a lump sum. That didn't happen. Then in late 2021, we had an agreement where he was going to pay a substantial discounted amount. We actually did a stipulated order to dismiss. We had to reinstate it. And so at this point in time, my client is not interested in trying to work out a resolution. Obviously, he can pay it. That doesn't mean I won't listen, but I can tell you that I talked with my client. They prefer to have the garnishment. In terms of the garnishment objection, Your Honor, the issue over service, the court rule requires that we give service to the garnishee defendant, and the garnishee defendant is to notify the actual defendant, which is exactly what happened in this particular case. There is no requirement that we give prior notice of a wage garnishment directly to the defendant. So the objection is not valid.
Anything else, Mr. Stanford?
No.
The case was before the court this morning for hearing on the defendant's objection to a garnishment. That objection indicates the address is wrong. I was never served, and I agreed to return the car to reduce the debt. We have a prior arrangement not honored. Court has had the opportunity to review the file and listen to the arguments of the parties, and will find that the objections are invalid. The objections will be denied in their entirety. The garnishee for mortar credit will immediately release all withheld funds to plaintiff's attorney and continue to withhold until the judgment is paid in full. The court is signing the order in the file that pertains to this matter. Copies will be mailed to the parties at their addresses as they appear in the court file. Is there anything else on behalf of the plaintiff?
Well, thank you, Your Honor.
Anything else, Mr. Stanford?
No.
That concludes this matter. You're free to go. Have a good day.
Thank you, Your Honor.
Thank you. Ms. McLemore.
Yes, Your Honor.
You are here on this confusing and complicated case.
I am, Your Honor, and I do not represent the defendant in this matter. This was a small claims matter. We encountered this client when she was in landlord-tenant court, of course. And because of our funding, I'm not able, my manager did not recommend that we file an appearance because she is suing for damages, and we basically could raise those damages in lieu of in response, in defense of the landlord tenant matter, but not the small claims matter. So I am just appearing. I was just thinking that there's a hearing on this tomorrow, and that it just be put off till tomorrow for the case to be held, because there are similar, I mean, the facts are the same.
Here's the issue. There is a Noreen Miller, who represents the defendant in this case, the landlord in tomorrow's case, and tomorrow's case is with me as well. But when I see attorneys involved in cases that seem to have a similar set of facts and parties, I'm concerned that they're scheduled on 2 different days. And I see that the plaintiff in this case is here. Ms. Johnson? You're muted.
Good morning. Can you hear me now?
Thank you. I can hear you now. This is 230702 GC. This is Shantu Johnson versus Mac Tedla.
Yes.
State your name for me, please, ma'am.
Shantae Johnson.
Ms. Johnson, I was starting to have a conversation with Ms. McLemore regarding this matter because there are 2 different files that involve the same parties, but slightly different cases. The case today is your case that was a small claims case that was removed by attorney Noreen Miller. This case was scheduled this morning at 9:30. It's now 9:58 by the court's clock. This court has not seen attorney Miller. Have you had any communication with either the attorney or Mackinnon Tedla?
No, I haven't. No, ma'am.
Your Honor, I did have a conversation with, I know that the defendant's attorney did filed an answer when she removed the case. And I believe she filed a motion. But again, I am here basically as a spectator, so I'm going to shut up.
There is a motion to strike the complaint and dismiss the action. And there was no proof of service in the file, so I was not sure that Ms. Johnson had received a copy of it, but your indications that you've seen it, so we know that it's out there and it exists. But the court had questions because the motion to dismiss fails to specifically identify the defects of the claim, and that being the case, the court wanted to entertain argument this morning, but the defendant is not here. The defense attorney is not here to explain her motion more thoroughly and completely. That being the case, Ms. Johnson, how do you wish to proceed in this matter?
I want to continue on because this has been a lot. I just moved in there in November. I'm scheduled to have surgery and all this stuff. It's a lot going on.
Ms. Johnson, this is your small claims case that we're proceeding on tomorrow morning at 9:15. You are scheduled back here with me with you as the tenant defendant in a landlord tenant case. Before your small claims case, the case was scheduled for today. You are here, the defendant is not here. Did you wish to proceed on your claim for damages against the defendant?
Yes.
Ma'am, you filed a small claims affidavit and claim back on February 10th, 2023, indicating that, asserting a claim of $6,500 due to you from Mac Tedla. Is that still the correct amount that's due and owing to you?
Yes.
There are court costs of $70, filing fee. Just looking for the service fee. I don't see a proof of service for the underlying small claims action, but there must be one because the defendant submitted themselves to the court. Ma'am, based on the fact that this case was scheduled at 9:30 and it's now 10 o'clock by the court's clock, defendant having failed to appear, the court would enter a judgment in your favor for $6,500 plus the $70 filing fee plus the service fee, whatever it is that you paid to have this case served.
Mm-hmm.
Do you know what was that amount, ma'am?
$70 to get the paper filed. And then I had to go to the post office, which that was free. So, but I think it should still cover everything. Yesterday I received a light bill of 1308. It's a lot of stuff, so I don't really know. This is my first time being in court. I'm just trying to make it through it. That's it.
Well, ma'am, the defendant is not here on time. This court will enter a default judgment that shows that there's $6,500 due to you, plus the $70 filing fee. If you have your service fee, you can include that in the court cost, submit that judgment to the court for entry. That relates only to your small, well, not, I keep calling it small claims case, but it's been removed to your civil case where you sued your landlord. That
Yeah.
does not resolve tomorrow's case, and you will need to reappear tomorrow on the same case, on, not the same case, on the case involving the same parties, okay?
Yes, ma'am.
Do you have any questions, ma'am?
No, ma'am.
Thank you. That concludes this case. You're free to go. You might have to have a conversation with Ms. McLemore if you have any questions about what just happened. Other
Yes.
than that, I will see you tomorrow morning at 9:15.
Okay, thank you. Have a
Okay.
great day.
You're so welcome. Have a good
Bye.
day.
Bye-bye.
I'll see you tomorrow, Ms. McLemore.
Thank you, Your Honor. See you then.
And
That
can you
concludes
call
this
me,
court's
Ms. McNamara?
docket. We stand at, I'm sorry.
I was asking if Miss McNamara could call me. Can she still hear me?
Sure.
She's here.
Okay. All right, thank you.
That concludes this court's docket. We stand in recess until 1 p.m. Mary Ann, I'll take us down.